So the age of majority in the state of Maryland is 18. The school system under IDEA, your child could stay till 21, but over 18, it's age of majority, which means legally individuals who are 18 years of age or older are considered to be adults and are competent to make decisions for themselves. So they have the legal capacity to make, create legal documents, make decisions about their health care, make decisions about any type of decisions about where they want to live, whether or not they want to continue school, they don't want to continue school, finances, going to banks, managing their own finances. And HIPAA, which is the federal healthcare law, also is in tune to that under HIPAA, no one other than the individual whose healthcare documents and healthcare benefits that are to that person can receive any information from either a doctor or any other person that is managing and giving them healthcare without a permission from that individual. And an individual who does not have capacity to make those decisions and to voice their opinion of who they want to have access to their healthcare, that becomes a little bit of an issue where planning is so crucial, because 18 comes pretty quickly when you have a child with disabilities. The other thing that's down here at the bottom part of this slide is FERPA. FERPA is if your child turns 18 and let's say your child goes to a community college, either after high school or during high school, he or she's taken a class at a community college. If they are already 18 years of age, the college won't speak to the parents. It doesn't matter whether you are the person who is paying the tuition or not. FERPA rights, they transfer for college at 18. In Maryland, for FERPA rights under secondary education, it remains in place until they're 21. But for 18 is for college classes. So that's just something I always put up there just to have you aware of that. And there's a FERPA consent form that most students will sign when they're in college classes, because once you tell your student, oh, you're going to have to deal with financial aid, that usually tell, response right away is, where's the form, I'll sign it. They don't want to deal with financial aid, but that is something that comes into play when you have an individual that perhaps might be going to college. Next slide. So transitioning from being a child to an adult, from being in the school system to the adult world with an individual and a student or a child with special needs, there's lots of things that come into play. It can be a very scary time. The school system, as much as it can be difficult to navigate the school system under the IEP system, it is a structure that is it's a right when your child turns 21 in particular and goes out into the adult world. That right is not a right. It's not a fundamental right to be able to receive benefits. You have to qualify for them. It's not a fundamental right that the government has to provide your child with anything. Whereas in school, there's a fundamental right under IDEA that they are entitled to a free, appropriate public education. So transitioning is a little scary as a parent, because you don't know what's out there. Although in the school system, they start talking at the age of 14, it's supposed to be gradually getting more discussion and a plan put into place. So make sure that if your child is still in high school or age 14, that they are starting to discuss what's going to happen upon receiving a certificate of completion or a diploma, and how your child is going to be able to transition into that adulthood. The other thing that comes at 18 is that it is also a way to know also where the what kind of benefits are out there, what are they eligible for. So are you going to qualify them for SSI? Are you going to qualify them for DVA services? do they qualify for Medicaid? If you receive SSI, you automatically receive Medicaid in the state of Maryland. And then again, just, what kind of independent living or interdependent living or staying at home, and what does that look like for your child, for those parents that are attending tonight that are looking at what does a transition plan really look like, and what kind of things do I need to think about. If you're post-graduation, you've probably already done these, but if you're coming into transition or your child's still in elementary school, at age 14 is when you start thinking about these type of things and what needs to happen to get you to a spot where you're ready to apply for SSI, apply for DBA services and Medicaid. Next slide. So there's legal considerations with children with special needs and adults with special needs. You should be looking at your own estate planning. You should be looking at whether you need special needs planning, what type of healthcare decision making is your disabled child going to be able to manage, and what financial decisions is your child going to be able to manage. And then, of course, having the ability to understand the government benefits. I mentioned SSI, there's Social Security Disability Income, there's Section 8 housing, there's food stamps, there's just a wide variety of different types of government benefits that your child may be able to have access to and may be eligible for. So tonight we're going to talk a little bit about each one of these in ways that you can be helped as far as getting a good sense of what's out there. And if you choose to learn more about it, I can also provide you with some really good reading material as well, but really get a good sense of kind of like what needs to happen in the legal considerations as your child becomes an adult. Next slide. So the first thing is estate planning, and this estate planning that I'm talking about is really estate planning for you as parents. And then also we can talk about whether or not estate planning is appropriate for your disabled child and what that looks like if it's appropriate. So as adults and parents, it's really important, and I'm sure that when you put your head down at night, you really worry about what's going to happen if I predecease my disabled child. And that's a true worry. And it's hard, it's really difficult to grapple with that. And I think by having a really sound estate plan in place, which includes special needs planning, then that really lets you as the parent, sleep better at night. Lots of decisions in this. Who's going to take care of my disabled child when I'm gone? What if both of us die in an accident if we're married? What if we both die at the same time? Who's going to step into that role to help our disabled child? And what does that look like? So you should have a last will and testament. A last will and testament is a document, a legal document that basically describes and publishes, so to speak, your wishes of how your assets how you want your assets to be passed on to your heirs and your legatees. It's also a way to express, ways that you want your child to be taken care of, who you want to be guardian if you have passed away and you're the second of the parent to pass away, who's going to take care of that disabled child. It's also a way to cut down on the probate side after you die, probate side, in the sense that you're with a will, you are telling the court how you want your assets to be distributed, versus if you have no will, then the state of Maryland, through the Estates and Trust article of the Maryland Annotated Code, which is the laws of Maryland, dictate how your assets will go if you die without a will. So I think a will is a very important document for a family. And I think particularly a parent in a family that has someone who has special needs, it's really important to have one. The second document that's really critical is the durable power of attorney in Maryland. There's a statutory form, and what we do is a supplemental form because the statutory form is pretty narrow in what an agent can do. These two documents go to finances. So if you become disabled, so this is really planning prior to death, whereas a last will and testament is planning for after death. A durable power of attorney is planning for before death, whether you have it where it is effective upon signing, or whether it's effective when two doctors certify that you are incapable of making decisions for yourself. It's really planning for disability and also of you, and also convenience if you want someone to have the power to act even though you're not disabled. So for instance, our oldest daughter went off to college. She, well over 18. We helped her purchase a vehicle, was in another state. Unbeknownst to us, they said it was required to be tagged and titled in Maryland, not Colorado. And I wasn't going to pay my daughter, a round trip ticket of $800 some dollars to go to the MBA in Maryland. So I drafted a durable power of attorney, had sent it off to her. She signed it in front of a notary public in Colorado, and that provided the opportunity for my husband to go down to the MBA, get the tags, and then we spent $18 sending it to her via FedEx. So that's an example how a durable power of attorney can work while you're not incapacitated. And then, of course, if you become incapacitated, then this document becomes very important, because without it, then someone would have to go into court and apply for guardianship. An advance directive is also very important. The advance directive is going to speak to your health care and also end-of-life decision making. So it's a combination document where you have your health care, which is your ability to have your agent get past that HIPAA gate and be able to talk to your doctors, be able to get access to your health care records, and they will be able to disclose information directly to you as a healthcare agent. The second part of that document is a living will. So this is going to describe how you want your wishes to be applied if you end up being in a coma and there's no hope of you returning to life. There, you have injured your brain dead, so to speak. You're in a you have a terminal type of illness that death is imminent. These directives that living will is going to be telling the workers of what exactly you want your wishes to be, as far as being on a ventilator, as far as being able to describe what you want, nutrition, hydration, etc. So an advance directive is also a really important document. In estate planning, we often do trusts. We do testamentary trusts, which means a trust underneath your will. We do standalone trusts. We do trusts that plan for estate tax. There's lots of different type of trusts, family trust. I could have just a whole session on trust. There's just quite a lot of trust, but it can be a useful tool. Of course, in that trust bucket is the special needs trust, which we're going to talk in greater detail in this program. There's life insurance. What does that look like? Do you need life insurance? Do you want life insurance? How can you plan with life insurance? It's a really good tool when you have a special needs child to have life insurance. That's a really good way to fund a special needs trust upon your death, is with life insurance proceeds. And then retirement accounts. What is your beneficiaries? If you're married, under federal law, it has to be your wife unless they sign a waiver. But upon the second of you to die, what does that look like and how does that fit into your overall plan? So these are the type of things that we look at when we're doing planning. We always look at the, where you want your assets to go, what's the dynamics of the family, any special needs, absolutely, that's a discussion. And then, do you have an estate tax issue? Do you have low basis? Are we looking for income tax issues to be addressed? Are you leaving your assets to someone other than your children or your spouse? If that's the case, then we discuss inheritance tax, because in Maryland, there's zero inheritance tax for lineal heirs, which would be your spouse, brothers, sisters, children, grandchildren. If it's anybody else, and parents, anybody else than that, then it's pretty much, it's 10%, which is a pretty hefty, type of inheritance tax. So those are the 4 things that we really talk about. If you are in the scope of estate tax, then we have further discussions and heavier planning around that. So that's really estate planning in a nutshell. There's lots of tools in our toolbox in order to make sure that your wishes are carried out. Next slide. So special needs planning. This is my favorite part of my job, is special needs planning. I love to help other families that have children with special needs, loved one with special needs. It's just so important. So when we're doing special needs planning, we're really trying to plan for the individual with disability for now, for the future, and also to make sure that if they qualify or will qualify for any government means tested benefits, meaning there is a limit to how much income they can have per month, or how much assets total can they have in their own name, then special needs planning is highly recommended. So we look at the government benefits. Like I said, there could be SSI, SSDI, Section 8 housing has different rules. Food stamps have their own rules. So depending on the benefit, depends on what the rules are. So we talk about all that. If you're going to be able to qualify, if it's important for the child to have Section 8 housing, then a special needs trust can't be giving them a steady distribution every month, because then their rules, that's not, they will count that as income, and that will probably be a deal breaker. Whereas if you're talking about SSI, then you can't have more than $2,000, in assets at any given time. Same thing with Medicaid. Then we have tools in our toolbox to allow the planning where the individual can benefit from an ABLE account, or a first party special needs trust, or a third party special needs trust, or a pooled income trust. So there's lots of tools in our toolbox to make sure that those government benefits are protected legally, and that eligibility can continue currently and in the future. So we'll talk about special needs trust, and we'll talk about an ABLE account. We talked a little bit about guardianship. I mentioned it at the very beginning. So the healthcare decision making is also important. If the child is capable of making an advance directive, then that's the least restrictive, and it goes through a process of least restrictive. If they can go ahead and sign and understand and execute an advance directive or power of attorney, all the way to the most restrictive, which is guardianship. And we'll talk a little bit more about those choices. Next slide. So special needs trusts, there are several kinds. There's a first party special needs trust, which is also known as a D4A trust. This is going to hold the assets of the disabled individual. So for instance, let's say that your mom is still alive and your mom really wants to give your child, Abigail, who's disabled, an inheritance. And let's say that for whatever reason, she could not get her own planning together to make a third party special needs trust. and $50,000 comes to Abigail, and Abigail receives SSI and Medicaid. She can't have more than $2,000 to her name at any given time. So what happens? There's a fix for that. You can swing up to $17,000 currently a year into an ABLE account. So that'll get you down to 30, my math's right, like 33,000. You can, at that point, spend it, which would be probably difficult unless you're going to do a major home improvement to spend the $33,000 left. Or you can swing that into a first party special needs trust, or you can put it into a pooled income trust. The key there is that it's going to be in a first party type of trust, and a first party trust is going to have a payback provision under Maryland and federal law to Medicaid upon Abigail's death. That's the first party. First party only holds first party money. Nobody else's money should be in these types of accounts for first party. And that's because if you commingle someone else's money into a first party, then the law says that all of it becomes first party. So you want to make sure that the only thing in a first party special needs trust or a first party pooled income trust or an ABLE account that is a first party ABLE account, it only has the disabled person's money in that particular vehicle. How do you develop a first party special needs trust? What happens with a first party special needs trust is lawyer drafts it. It has to be drafted very carefully. There's specific rules. It has to have specific things in the first party special needs trust. Then that first party special needs trust, there is a petition to the court to request permission to create and fund a first party special needs trust. And from there, it gets sent over to the Maryland Department of Health. The Maryland Department of Health reviews the trust. There is a checklist. They go down the checklist, which is basically everything that's in the statute, and they check it off to make sure that the trust is got those items in it, and that there's nothing in the trust that would warrant the trust being counted as an asset for eligibility purposes. Once the Maryland Department of Health signs off on the trust, they stamp it as approved. Then you get your court order, and then you're ready to sign the trust and fund the trust. That's the first party special needs trust. So how that would work is, let's say that grandma wants to give $50,000 to Abigail. Grandma dies, did not do planning. There's $50,000 coming from the estate. The estate would be asked to hold that $50,000 until court order is done. The petition is filed. Court signs the order. The MDH review is complete. The trust is ready for the $50,000. At that point, the $50,000 can come into the first party special needs trust in the same month that the trust is approved, because you need to be moving the money in the same month so it doesn't show up on the beginning of the first month as an asset. So there's a little bit of a timing issue there, but estate planners that do special needs planning are very familiar with that timing issue. That's a first party special needs trust. There's a second type of first party special needs trust. It's a pooled income first party special needs trust. And that's different. That's going to be with typically a nonprofit organization. In Maryland, we're very fortunate to have First Maryland Disability Trust. We also call it FMDT. And it is a pooled income trust. You can open a first party pooled income trust or a third party pooled income trust with FMDT. So let's say that same $50,000 coming from grandma to Abigail. Let's say, we decide we don't want to do our own first party special needs trust. We want a pooled income trust. We would then go to FMDT, tell them we want to set up a pooled income trust for our daughter. And how will that work? And it's very simple. It's paperwork. You set it up. FMDT would be the trustee. The trustee they have a schedule of payment for their fees and how much it costs. And the $50,000 would go into a trust that would be earmarked for Abigail. So it'd be Abigail's account. And it's sort of like a 401k at work where, at 401k, you have, Bobby, Susie, Johnny, they have their own accounts, but you're pooling the income, you're pooling you share in the income, you share in the expenses of the 401k plan. Same type of philosophy of a pooled income trust. You're sharing the income and the expenses get spread out between the accounts. Upon Abigail's death, the first party pooled income trust, Medicaid would be paid back, and anything left, you have an option. You can select it to stay at First Maryland Disability Trust to help with costs, or you can select it to go to whomever you want it to go to. So that's the two options of the first party special needs trust, which is also known as D4A trust. The second type of special needs trust is the third party special needs trust. So a third party special needs trust is a special needs trust that is created and funded with third party money. So this is not going to be the grandma leaving Abigail $50,000. This is going to be, mom and dad of the disabled child, their estate planning. You set up a third party special needs trust for your disabled child. It can be typically it's a standalone. Typically you can have two kinds. You can have a revocable or you can have irrevocable. A revocable trust, you can revoke at any given time. An irrevocable trust, you cannot revoke it. You cannot amend it. You can, on limited circumstances, go into court and ask for a modification. But generally speaking, once you create that trust, you can't revoke it. And once you fund it, you can't take the money back. It comes out of your estate for estate tax purposes. It's a completed gift once you fund it. But the point being is that you cannot go back and take it back. So you have those two types of third party special needs trusts, revocable and irrevocable. When you have a third party special needs trust, you typically will plan, you have two types. You can put it underneath your will. So the third party special needs trust is not even created until you die. Or it can be a standalone inter vivos trust, which means during your lifetime, you can create this special needs trust, inter vivos, sitting there, and then you can direct your will, your pour over of any type of bequeathment that you want to give your disabled child. It would pour over, your will pour over into this standalone third party special needs trust. Then grandma can point her $50,000 distribution to that third party special needs trust. Your brothers, your sisters, siblings of the disabled, they can all pour their wills or pour their assets that they want to leave the disabled person into this particular trust. And that trust is not counted for means tested benefits. And that's another reason why you don't want to commingle first party with third party, right? Because it's totally separate. It doesn't get put into the picture at all. This third party special needs trust can be used to supplement, not supplant, the government benefits. So for instance, from this third party special needs trust, you would be able to pay for things like, let's say your child needs occupational therapy and the insurance doesn't pay for it, Medicaid doesn't pay for it. You can go ahead and pay for it out of the third party special needs trust. Let's say there is a really cool, type of chair or some type of, musical instrument even that your child really enjoys. You can use that money to buy that instrument or that particular chair, as long as Medicaid's not buying that particular chair. Other ways you can use the money is for vacations, respite care, just personal items that aren't being covered out of the SSI. Let's say you get, currently SSI is $914 a month. You have to be paying their shelter and their food from SSI first, but let's say it doesn't cover all of it, then the third party special needs trust can come around and wrap and help with that. So there's a variety of things you can do with the third party special needs trust. It's there to make a quality of life better for the child, other than that, 914 doesn't go very far, especially around here. So that's really the beauty of third party special needs trust. You can plan where you take out a life insurance trust and you name that standalone third party special needs trust as the beneficiary of your life insurance policy. Then that's a good way of funding that third party special needs trust after your death for your disabled child. So that's another example of how you can set things up. We talked about pooled income special needs trust. There's also at FMDT the ability to create a third party special needs trust, a pooled income trust. It works the same way as the first party pooled income trust at FMDT. Except the difference is that there's no payback provision to the state of Maryland or any other state that provides any medical assistance, Medicaid to the disabled child. So with a third party special needs trust, whether it's a pooled income or a regular third party special needs trust, there's no payback provision for the amount of Medicaid benefits that are paid out by the state or any other state. If you happen to live in another state and your disabled child receives Medicaid, they will also be part of the payback. Now, regarding paybacks, let's say you have a first party special needs trust and there's $500,000 in it when your disabled child passes away. And let's say Medicaid comes back and says, okay, we've paid $100,000 worth of Medicaid benefits for your child, and we're going to put a lien against the trust for $100,000. So $100,000 get paid back to the state of Maryland. That leaves $400,000 that gets distributed pursuant to the trust agreement. But let's say there's $500,000 at the death of your child, your disabled child, and let's say Medicaid has paid $700,000 worth of Medicaid benefits throughout your child's lifetime. There's only $500,000 in the first party special needs trust at the time of the death. The lien is put against the $500,000. $500,000 gets paid back to the state of Maryland. Zero gets paid to any of the beneficiaries named in the trust. However, no one pays the difference of the $200,000. Okay, the lien doesn't attach unless the assets of the disabled individual have other assets that are in the estate that there is $200,000 more, and typically that's not the case. So they can't ask, the point being, they can't ask anybody else for that $200,000. So I think that that's a really important part to understand, because that's scary, right? If you didn't know that particular fact, it's really crucial, I think, that you know that the payback only goes up to the amount of the trust and any other assets in the disabled child's estate, if any, for a payback, and no parent is responsible for paying the difference to the state of Maryland. Next slide. So we're going to shift a little bit to ABLE accounts. ABLE account has been a great tool for individuals with disabilities and their families. It really, I think, when this occurred on the federal and state level, and it hasn't been but several years now that we've had ABLE accounts, it really has been just a terrific tool. And there's ways that you can use it. So the first thing is, are you eligible? Is your child eligible for an ABLE account? They're eligible if they have a qualifying disability that began before the age of 26. They must meet the Social Security Administration's definition of disabled, or if they don't, then they have to have a disability certification signed by a licensed physician and the disabled individual is over 18 and beneficiary of the account, or the ALR for the beneficiary, which is the authorized legal representative of the beneficiary, can also help with the eligibility. So that's the eligibility for the ABLE account. The ABLE account in Maryland is ran by Maryland 529. It's the same individuals that are responsible for managing the 529 plans here in the state. So ABLE is ran pursuant to the federal and state laws that center around ABLE, but the actual agency that handles the management of that is the 529 people. Next slide. So what are the basics of ABLEs? I mentioned that the beneficiary or the authorized legal representative who wants to set up an account for a disabled beneficiary has to be over the age of 18. So in other words, your Abigail's sister who was 16 can't get online and open an ABLE account for her disabled sister because she's under the age of 18. You can place up to $100,000 in the account without it affecting your SSI and Medicaid benefits. If it goes over $100,000, it will suspend your SSI benefits, but your Medicaid benefits will continue. Once you bring that account down below $100,000, then SSI will continue at that point. You can put into the ABLE account currently $17,000. It gets adjusted each year. It's tied really to the gift tax exclusion amount. So for 2023, you can put $17,000 up to $17,000 into an ABLE account. So if you remember when we did the example about grandma and $50,000, I originally said you could put up to $17,000 in an ABLE account, and then the rest could go into first party special needs trust where you can spend it. That's the reason is that only $17,000 in 2023 could you can put into an ABLE account. You have a lifetime contribution limit of $350,000 into an ABLE account. You also, as a taxpayer, let's say you as grandma decide you want to open an ABLE account. You can open an ABLE account for your disabled granddaughter, and you could potentially get a tax credit on your Maryland state tax return for the year that you create the ABLE account. So not every state that have ABLE accounts do this. So it was refreshing to see that Maryland actually gave us a little bit of a break to set up an ABLE account. Next slide. So what are these eligible expenses? So an ABLE account, you can use the money in the ABLE account for certain expenses. And here's a list. It's not exhaustive. It's just some of the items that you can use ABLE account money for on behalf of your disabled child. So living expenses and housing, transportation, that's always an issue. Health prevention and wellness. Let's say that they like massages or massages really help them. You know, you're not going to be able to use, any type of medical benefit for that. So that's another way that you can use the ABLE account money. You can use ABLE account money to pay for legal fees. If you need to go for guardianship, you can use that money. If you need to set up a first party special needs trust, you can use that money in the ABLE account to pay for the legal fees. Funeral and burial costs. With that though, I put a little asterisk because there are some limitations on what you can do with burial on other government means tested. So it's always good to inquire with an attorney that has a concentration on special needs plan on how that actually works depending on your circumstances and how you want to handle the payment of that and what benefits your child might be on or may qualify. Assistive technology is another way you can use the money, respite care, vacations. It's really to supplement and quality of life, the quality of life issues, quality of life benefits for the child. Park passes, if your child happens to, I know when Abigail was growing up, I don't know what it was, she really enjoyed going to Busch Gardens in Williamsburg. I think it's the roller coaster, it vibrates, and she got a big kick out of it. And so she enjoys doing that. That's something we could use her money from the ABLE account on. So that's another example. Next slide. So healthcare decision-making is another thing that is really important. We talked a little bit at the beginning about healthcare decisions. So really the question is your child, your young adult, do they have the ability to consent or withhold consent for medical care? That's, do they know the bounty of their desire? That's really the test legally of whether or not they are competent enough to create and sign a advance directive, and also any type of estate planning document, to be honest with you, that's the test. As practitioners, we actually look towards the doctor. I know in our practice, we ask parents to, if they think their child is capable of making an advance directive and a power of attorney, we actually ask for a certificate from the doctors stating that under their belief that they are capable of making those documents. And that's really to protect everybody involved. And also, do they have the ability to employ and discharge healthcare providers? Do they understand what going to the doctor means? Do they understand what the doctor says? If the doctor says, Susie needs an MRI, do they understand what that means? Those are the type of discussions that an estate planner is going to have with you as the parent to try to determine whether or not there's capacity there to make an advance directive. The last bullet here is the consent to the provision of the withdrawing. And this goes to the living will portion of the advance directive. Do they understand the concept of death? Do they understand when you're in what does it mean to be in a coma? Do they understand what means, nutrition? All those hard decisions that for an adult that does not have disabilities, it's very difficult. But do they have the capacity to understand that? So that also goes into whether or not they're capable of creating an estate planning document that discusses healthcare. Next slide. So there's some decision-making documents that we typically see in our practice area. The first one is a MOLST. MOLST is a medical order for life-sustaining treatment. It's basically an order that is signed by the doctor that states what the wishes are of an individual. It centers around, do you want CPR? Do you want a resuscitate? Do you want resuscitation or not? That's a MOLST. The other thing is, the advance directive is another tool. Those are the least restrictive. So if your child is capable of signing an advance directive, they're competent enough, they understand the bounty of their desire, the doctor has signed off on that, then that's the way to go, right? A MOLST and an advance directive. If they can't, then we go up like there's a spectrum of least restrictive up to the most restrictive. So the least restrictive is going to be being able to sign an advance directive, being able to have the doctor fill out a MOLST, be able to understand what you want as a disabled individual, how your healthcare goes. The next is the surrogate decision-making. Surrogate decision-making is where you are having conversations with your parents or another loved one. You want them to be helping you make the decisions. It's not an agent, it's helping the disabled individual make those decisions. It's as if you are saying, okay, I want my sister, to talk for me. Okay, but they don't, if your sister talks for me, but I don't agree with what my sister's saying, then what I say overrides what my sister says. Okay. Supported decision-making is new. It's a new law. It's effective October 1st, 2022. I have not seen a lot of supported decision-making yet in my practice. It's not widely tested yet. What it basically is it's an agreement between the disabled individual and the person who's going to be the one actually helping the disabled individual make decisions about healthcare. It's almost like a small contract in a way. Don't know whether or not it's being widely used at this point. One of the things that I will tell you that I see all the time in my practice, and I've experienced it personally myself, is that the larger hospitals, their risk management departments are very strict. You turn 18, boom, unless you have an advance directive or a guardianship order, they're not going to entertain anything else. We are hoping as a bar and a states and trust bar to make sure that those hospitals and other doctors and other physicians understand that the surrogate decision-making and the supported decision-making is Maryland law, and that there is a place for this because of the spectrum. But a lot of parents do have a fear that if and when they need to act for their child or their adult, that if they don't have a advance directive or guardianship, they're going to hit a buzzsaw. I've had clients who've gone, their sibling, their siblings advocate, they've gone 30 years without an issue. I have had parents who have issues from day one. So it's like this, there's no rhyme or reason to it. That's just been the experience of myself and my colleagues of when you don't know when you're going to hit that brick wall. But again, it's important to look at the least restrictive all the way into the most restrictive and what is best for your child, because you really, we all don't want to put extra restrictions when it's not necessary. So I'm really proud of the fact that we have the supported decision-making in the state and also the surrogate decision-making, because it is a least restrictive environment. And there are some individuals who can utilize those tools and it run perfectly smoothly. There's other individuals who are much more disabled who clearly cannot make those arrangements. And then you're now moving into the most restrictive, which is the guardianship. And there's definitely a process for guardianship in the state of Maryland, and there's also fees associated with it. And we'll talk about guardianship now. If you want more information on the surrogate decision-making and supported decision-making, the Maryland Department of Disabilities has a really great website, and they have some information on that there. Also, the Maryland Disability, used to be called Maryland Disability Law Center. They also have on their website some information. And of course, you can always reach out to me. I'll be happy to provide you with some more information on those two decision-making avenues. Next slide. So I went right through supported decision here. So this is how it works. Enables individuals to make, communicate, and effectuate decisions using support from trusted individuals. It's a person-centered framework, and persons with disabilities remain the decision maker. And the person that they're named is their supporters. They can't decide if there's a conflict, then the disabled individual's decision is the one that rules. Next slide. So guardianship. There's two types of guardianships in the state of Maryland. There's guardianship of the person and guardianship of the property. If your individual child is over 18, this only is, you have to be 8, the child has to be 18. It cannot happen prior to being 18, because as a parent, a natural parent, adoptive parent, you already have the rights to act on behalf of your child. Remember, at 18 is the age of majority. So at 18, they become their individual on their own. They have a legal right to be their own. And until deemed incompetent, the world's going to see the adult disabled child as being competent to making all the decisions as a competent adult can make. So the burden is to show, if they can't, to show that they cannot make decisions on their own and the reasons why. It has to be judicially deemed to be incompetent. So guardianship of the person and guardianship of the property. If your disabled child will only be receiving SSI or SSDI, and there's a representative payee that's required by the Social Security Administration, and that is the only thing your child has, you do not need guardianship of the property. If your child has money in a bank account, then what I tell parents, if the child's turning 18, say they have $400 in a bank account, my advice is always go spend the $400, because then you don't have to get a guardianship of the property, which requires annual reporting, oversight by the court. You have to account for every penny. So go open an ABLE account with the $400. Just it has to come out of the individual's name before they turn 18. The guardianship proceeding is you file a petition. It's a detailed procedure to protect the rights of the individual who is the subject of the guardianship. The individual who has been adjudicated in a court of law as being incompetent will require a guardian until a guardianship is not necessary. There are instances where a guardianship is terminated. When is guardianship necessary? It's necessary when those least restrictive avenues are exhausted, meaning the disabled individual cannot sign an advance directive, they can't sign a power of attorney, for some reason, supported decision making isn't working, then you're back to the most restrictive guardianship avenue. And like I said, the individual is 18 years age or over. Next slide. So what is the process? The process is very straightforward. The judiciary actually had a large task force a few years back that really looked at guardianship and did a nuts to bolts overhaul and making sure that procedures and processes are put into place. And frankly, they did a really nice job on that. So the first thing is, where do you live? It's, the disabled individual lives in Baltimore County, then the petition is going to be filed in the Circuit Court for Baltimore County. If they live in Anne Arundel County, it's going to be in Anne Arundel County. Whatever county or city, meaning Baltimore City, that the disabled person lives in is the county or city that you're going to file the petition for guardianship. You're going to then get some certificates, which we're going to talk about in the next slide in more detail. Then you have to serve the guardianship petition, the advice of rights, notice to interested persons, the 2 certificates that are going to be required. You have to serve them on every interested person in the matter. Also, the court is going to enter a show cause order, which tends to scare some people, like, oh my goodness, what is this? A show cause order is that it's an order saying, we need you to come to court and show cause of why this petition should not be granted. That's what a show cause order is in basic terms, okay? And it can be pretty daunting if you aren't used to getting one. They will also appoint a court-appointed counsel, and the court-appointed counsel will be your child's lawyer for this proceeding, okay? Then there will be a hearing on the merits. And if anyone objects to the appointment of a guardian, then they have to come to court and they have to say why. Then if you are appointed guardian, then you have to go through an orientation, which is about a 45-minute training, and then another training about being a guardian of the person and or guardian of the property. These are videos that are on the judiciary website. They're about 45 minutes each. Then you have to submit a certificate under penalties of perjury that you did watch it and that you understand what your roles are as being guardian. So that's the overview of the process itself. Next slide, please. So when you're petitioning for guardianship, again, it's in the city or the county that the disabled individual lives in. You need to demonstrate why your child needs a guardian. I often tell my parents, everyone, I know I do with Abigail. I love to talk about how wonderful she is and all the wonderful things she can do. This particular petition, you need to keep that at a low roar and dive into, unfortunately, what your child cannot do, because the whole point is to show in the petition, show to the judge that your child needs a guardian, and this is why. This is what they cannot do. For instance, they don't know what 911 is. They wouldn't know to get out of the house in a fire and call 911. They tend to dart out in the middle of the street without more turning left or right. They can't cook for themselves. They need help, bathing. They need help, dressing. Those are the type of things. They're very vulnerable. If someone comes around and says, "Hey, come get ice cream for me and with my puppy dog," are they going to go with them? These are the type of things that we build into the petition in order for the judge to understand why we're petitioning and the fact that the child really does need some assistance full time, so to speak, in order to have a safe life and to have health care taken care of and finances if that's appropriate. The court decides the validity of the guardianship petition. The parties to the petition are the petitioners, the alleged disabled, the court-appointed counsel, and the interested persons. The interested persons are going to be any siblings of the disabled individual, the alleged disabled person. And if they're receiving government benefits, so let's say they are receiving SSI and Medicaid and DDA services, then the Maryland Department of Disabilities Administration will receive notice, which would be DDA. Then the Maryland Medical Assistance Program and the Social Security Administration will all receive notices. And then the Department of Social Services in the county that the disabled individual resides is also an interested person. Next slide. The certificates that I talked about there, this is very important when going for guardianship. You have to have a physician certificate and then one of the following. And so you have two certificates you're going to need. One has to be a physician certificate, and that physician typically is the one that does an exam of the child within 21 days of filing the petition. That's so crucial. So what I usually tell my parents is this: all right, you're going to do not make an appointment with the general practitioner yet. You're going to go get one of the other certificates first. That's going to be a psychiatrist or a psychologist or a licensed clinical social worker. Now, most school psychologists can complete this. Most school social workers cannot. A licensed clinical social worker, you have to ask a social worker, are you a licensed clinical social worker? Because there's a difference. You either are or you aren't, and it's a separate type of a licensure that the court's requiring. Once you get one of those certificates in hand, then you make your doctor's appointment with your physician and get them to do the exam and complete the form. So we have everything, we're ready to file immediately within 21 days of that exam date in order for the certificates to be accepted by the court. I've had problems with getting the outdated certificates it's a non-starter. They will immediately reissue new summons, reissue new show cause orders, and then you have to reserve everybody again. You have to go get the certificates. So I've learned through the years that go get the other certificate first, and then go back and get the certificate that requires the exam. And it's been working pretty well since I've decided that that's the best way to handle it. Because there's nothing worse than having to go back to the doctor and get another exam. So, okay, next slide, please. You can have a contested and you can have a non-contested hearing. If someone is contesting it, it's a litigation issue that becomes a whole different ballgame. Typically, unless you have some issues within the family dynamics, typically everyone will consent to your disabled child having a guardian if that's what's needed. Jury trials has to be waived. So everyone's right to a jury trial. It has to be waived. The court-appointed counsels will waive the jury trial necessity. Some will ask for the disabled individual to be present at the hearing. A lot of them don't. It's really whether or not they think that they can add value to the proceedings at that time. Some counties, for instance, Anne Arundel, want the person to be there regardless, so they want the child to be in court. The burden of proof is clear and convincing evidence. The more you give examples in your petition, the better it's going to be, and less testimony is going to be required at court. And then it's in the circuit court in most cases. If the child is under 18, and this is a different type of a guardianship, both parents have passed away, the child's under 18, there's nobody named as a guardian, there's no family member left, that can be brought in orphans court, but typically it's in circuit court. Everything else is in circuit court. The circuit court judges, I will say, throughout the state they are very nice. They understand the situation with individuals with disabilities. They want to be part of the help. They have these rules and regulations and the law to follow, of course, but they have a great deal of empathy. And the bar is very appreciative of that. And the bar that does guardianship work, there's several lawyers that a lot of us do a lot of these, and we know each other very well. And it's just a really it's nice to know that there's lawyers and judges out there that understand the issues, who want to help parents out, make sure that the individuals are safe. Some judges will do the hearing where it's on the pleadings, what we call on the pleadings, which means that they take the petition, they read it, they understand it, they have been persuaded by clear and convincing evidence that the child needs a guardian. So when it comes to the hearing, they hear from the court-appointed counsel. The court-appointed counsel typically will agree with everything. Then we enter the certificates into evidence, and then you're appointed. Some judges want live testimony, so we go to court. The parents are put on the stand. We ask a few questions. The court-appointed counsel has the opportunity to cross. They typically don't, because the questions are pretty straightforward. Then the certificates are entered into evidence, and then the judge will rule from the bench and appoint the individuals who are petitioning. If it's consented, like I said, if it's if it's contested, then it becomes literally an entire litigation, and that could last for a day, half a day, whatever. They usually will reschedule that and determine how many hours it's going to be to litigate those issues. I think I've had one contested out of all my years of doing this, so they're not that common. Next case. Next slide, sorry. So when you're adjudicating an individual, a disabled child, to be incompetent, what does that mean? It's really adjudicating of a disability for the purpose of appointing a guardian, and it's not a basis for any type of a commitment to a mental institution. It's also the appointment of the guardian does not modify any civil rights unless the court orders it. Some parents will say to me, I still want my child to be married. Yes, we can ask that to be placed in the order. Some individuals, the parents want their adult child to be able to vote if they want to. We can request that. So there's things that can be added to the order on civil rights. If there's something that is really important to the child and for the parents, then we can include that in the petition, and the court can rule on it. Next slide. So what's a guardianship responsibility? I talked about the training. You have an annual report of the person, annual report of the property, if there is a guardianship of the property. And then you really need to make sure you have a good plan, which I'm sure you all would, of maintaining the well-being of your disabled child, and also act in fiduciary capacity, loyalty, duty of honesty. Just make sure that you're doing what's best for your child. The guardian is actually, this is something that most people don't realize, but the guardian is actually the court, and the guardian who's appointed is the agent of the court. So that's always something, a little tidbit that's a little interesting I tell my parents about. Next slide. So some practical tips. If your child's under 18 and is approaching 18, make sure that they are getting the transition planning starting at age 14 in their IEP meetings. Start educating yourself on Social Security benefits, Medicaid benefits, Section 8 housing, DDA, all the different types of benefits that are available that your child could potentially be eligible for. Look at your estate planning documents if you've done some. Do they need updating? Laws change all the time. There was a change in the Power of Attorney Act in Maryland that's being effective October 1st, 2023. So there's lots of times that laws do change, and those requirements change with it. And maybe you're in the position now where you can create a special needs trust, and you need to do that. So it's always good to think about whether you have a sound estate planning documents in place, and if not, what you think you would want to do, and seek out an estate planner and someone who has special needs planning background. It's not out. There's a handful of us that do this in the state. It's very different. You really need to know your government benefits, and to make sure that you're not advising with something that will make the child become ineligible for benefits. This is a big one. Develop a functional system to maintain records. Build a library of things that are useful for you and your child. And as your child grows, and you identify an individual that's going to take over when you're incapable of doing that, it's helpful. It's helpful to have, what your child likes, an intent letter. What doesn't work with your child? I know, when Abigail gets frustrated, this is what it looks like. What does that look like? What type of benefits are they on? Little bit of, like, today I was doing Abby's SSI report. That's got to be done every year, and this is how we do it. This is, you get a reminder. Those type of things. It's always helpful to have a system down. And then identify and utilize resources to the best of your abilities. Seek out other parents that have children with special needs. It's, there's so many, just like the SAGE, organization, there's so many organizations out there to help. And I think that that's, really critical as well, is to make sure that you have plenty of resources at your fingertips. Next slide.